of the agenda. Can I get a motion?
I can move to approve the agenda as posted.
Second?
Second.
Discussion? All right, all in favor?
Aye.
Opposed? All right, that motion passes. Any announcements? All right, seeing none, let's move on to board review and possible action on ordinance TBD 2022. All right. Mr. Bruner, would you like to address the board?
No.
Okay. Mr. Bogdan, would you like to say anything?
Yes, just a brief introduction of this matter. I think everyone knows this, but we'll kind of recap things briefly to date and what you have in front of you. So as you know, there was a citizens initiative petition related to records and municipal court jurisdiction. That initiative has been referred to the voters for consideration at a special election on May 3rd. State statute allows that a petitioners committee could withdraw that ballot and that initiative in writing if that's done at least 60 days prior to the election. In discussions with the petitioners committee, specifically Mr. Bruner, he had indicated to the town that if the Board of Trustees was willing and did adopt an ordinance that addressed a more narrow scope of issues, that the petitioners committee would be willing to withdraw that initiative and there would not be an election. So at the last Board of Trustees meeting, I was directed by the board to prepare the form of an ordinance that's in front of you tonight, which in its essence uses the principles in an ordinance that Mr. Bruner drafted and tweaked them a bit to fit within Cora primarily. And so the ordinance in front of you does two main things. One, it says that public records of the town that relate to infrastructure and finance, that even if they may be withheld under Cora, and just to step back, they're public records of the town that under Cora that may be withheld and shall be withheld. And what this does is with those records related to infrastructure and finance, in instances where they may be withheld, this ordinance would have the effect of declaring that they won't be and that they will be produced if there is a Cora request. The second thing this ordinance does is state that the trustees shall have access to public records and facilities, and with the clarification that would be subject to any policy adopted by the Board of Trustees and upon proper coordination through the town administrator. And that's just a function of the organizational structure of the town and coordinating those types of visits, and there be policy reasons not to just have open access to those types of facilities. I had some dialogue with Mr. Bruner on the ordinance on Friday. It's my understanding that he is in agreement with the form of the ordinance. Bill, just so you know, I did the last version that's in the version that's in the packet is the last one that I sent you with that change to the title that you and I had emailed back and forth on. And I also, at the board's direction, I had prepared a draft letter to effectuate the withdrawal of the initiative for the petitioners committee to sign. And I think that's my background. It's up for the board to decide whether or not they'd like to approve this ordinance in its narrow scope. And it's our understanding that if it is approved, that the initiative petition would be withdrawn and there would not be an election on May 3rd.
Yes, Mr. Bruner.
Can you see me, Jeff?
I can. Yep.
Great.
Just not your face. Yeah.
Hold that. So just 2 points to reiterate on this. It's the right of inspection. The clause at the end that inspection shall not be unduly delayed kind of overrides or influences the previous language that a trustee cannot be denied access. They have the right of inspection when you come down to it.
They have the right. It just needs, my understanding of how this or vision of how this would be implemented is that there'd be the right to inspect, but and it would be done so in a timely manner, a manner that wouldn't be unduly delayed, but there could be good reasons for proper timing of it. If there's maintenance going on of a certain facility, if there's a need to coordinate with the person or contractor or employee who kind of has the manages or has the custody of and control of the facility, and to otherwise not incur unreasonable expense in trying to arrange for one of these visits. So reasonable things like that would fit into that shall not be unduly delayed provision.
So tell me, I mean, if a trustee felt they had a burning issue, they needed access, if this says that a contractor can say no, we're going to change the if they have a right to inspect. If that is not baked into the core of it, we need to work on this. They have to have the right to inspect.
Yeah, Mr. Conklin.
And my response would be based on how we've drafted that is that they have the right to inspect and it will not be unduly delayed. And that you can't, when you draft the legislation, you can't encompass in every factual scenario to account for it in the text of the ordinance. But if there is a pressing need for trustees to view a public facility, that would be something that would need to be timely responded to. And, with those types of, with all those various factors in play. So yeah, I think that would be, if there's a pressing need to view a facility, and then that would need to be facilitated in a quick manner and an appropriate manner.
Do you guys understand that?
Yeah.
And any policy that gets baked out of this is going to incorporate that. It's a right to inspect.
Yeah. Okay.
And I just wanted to say at the last meeting, I created some language that I think what's really important here is that a policy be created about how you go about getting into a facility. And I think contracts or the scope of work should include language for that contractor to understand the policy, that there may be trustees through the administrator will ask to inspect facility. So I think there's two things that we need to do to follow up to this initiative that I think it can be easily rectified through policy and or resolution and introduced into all the contracts for those entities that are administering water treatment in this case. So, and I would not do it today, but I would propose some motions for our next meeting to get at those same points.
Okay.
Yeah, Mr. Johnson.
Yeah, and I would agree with Trustee Smith on those issues. I would also say that trustees have a right of inspection through facilitation through the town administrator. Not that the trustee can just show up and say, I want to see that. I think they need to go through the town administrator.
So the only question.
And that's how this is written.
Pardon me?
And that's how this ordinance is written, that inspection would be coordinated through the town administrator.
But the administrator cannot say no.
Right.
Say that. The administrator cannot say no.
Well, we have to put it in a policy.
I'm not making a motion.
No, I want you to, I want to know that we have the same understanding.
Yes, we have the same
Then
understanding.
please say it.
This is a little out
The
of.
administrator cannot say
Okay.
no.
I'm not going to say it.
All right.
You're not going to say it, then I'm not.
Okay.
I'm gonna
I
say
will
that.
I will say it.
Okay? Say it. Please.
Okay, how do you want me to say it?
The administrator cannot say no.
Yes, Mr. Knudsen.
Point of order.
Yes. What is your point of order?
If you do not agree to this language, Mr. Luna, then we will take a vote to the public that will be blatantly against Colorado law and ask them to vote on that. You will be the one that will be charged for the campaign to vote for something that doesn't apply to the law. I don't think we're here on, we don't want to take it to the voters for something that doesn't comply with law, and I don't think you do either. But to try and force a trustee who's one trustee to say something in the middle of a meeting, I think is blatantly unfair. And I feel like you're trying to force a trustee to say something that he's not ready to say. All we're here trying to do, and see, this is one of the things where an ombudsman would really be helpful in stuff like this. When a citizen has a real problem and needs a representative on their behalf, that would be helpful for this. But I'm really disappointed that we can't get to, I think we're going after the same thing. We as trustees want records. We want access to records. Some of us have been blinded by this. And I think you also want to make sure that the town complies to this stuff. I think you're hearing a commitment by the people sitting at this table that yes, we're on the same page with you. I want to prevent you from walking out in anger. That's why I'm talking right now. Thank you.
Yes.
So is it time to make a motion on this? And the reason I ask the question is because I believe that the motion to accept this ordinance could also contain the language that pins the trustees following up with a very clear policy on access and how the process is to be done. To be done, I want this to be on the agenda at our next board meeting, and that would be my motion.
So I would suggest to do two motions.
Mhm.
The first motion would be to accept the vote.
Mhm.
Then the second motion would be to set a policy discussion at the next, or to have a draft policy at the next.
Yep. That would get at Mr. Bruner's concern that there could be some, I don't even know the words, restrictions on the trust, undue restrictions.
Right.
Whereas if there's a policy adopted, which is what I would like to see, and I had motions to that effect last Tuesday, but we could do that, I think, in a very cogent, responsible, forward-thinking way. So that would be my overture to you, Mr. Bruner.
All right, so what we're here is part of a negotiation, all right? And I'm trying to be sure that I hear each one of you are cognizant and agreeing with the negotiation, the settlement. And the bottom line of that settlement is you have the right to inspect and you cannot be told no. And I'm hearing people not willing to say that. And so I'm thinking, do we actually understand each other?
Okay.
Okay, so if you can somehow convince me that you all understand that, I'm willing to hand in the release on the election,
Okay.
but I have to be assured of that.
Well, Mr. Bruner, it seems to me the language of this is pretty clear. And Ms.
We have a
Smith,
problem.
oh, yes, Mr. Conklin, please.
Sure. Thank you. I just wanted to reiterate the language of the ordinance as it's drafted, which it states that, although I have to read it, I have to pull it up on my phone, that that the Board of Trustees shall not be denied access to view all facilities of the town in accordance with any applicable procedure and upon coordination through the town administrator or town administrator's designee. Inspection of town facilities shall not be unduly delayed. So with respect to whether the request can be denied, it's not the case that there would be a no, but more of a reasonable when. And I think that's the intent of that language for the board's consideration, is that, each trustee can't have there may be good reasons to not have immediate access available to each and every trustee at a moment's notice, and they would need to be coordinated. And there's built into this ordinance the room for a policy that we're discussing here that might provide better procedure on how such a visit could be coordinated. And so anyway, I just kind of wanted to fill in some of those questions that it sounded like we were kind of bouncing around there on that language.
And from my perspective, it very much says cannot shall not be denied. And if everyone votes aye on that, they are agreeing to shall not be denied. Okay. Yes, Mr.
Well, I know at the end of our last meeting, Bill approached us about being very adamant about the word shall being in the ordinance. I'm very pleased to see in clauses that are critical, the word shall is there. So when I read this, I thought, oh, this is going to satisfy the basic requirements of what we're doing. So,
Did you have something to say, Mr. Thompson?
I feel like we're rushing into a new draft of ordinance to beat a deadline that we don't need to beat. And I would motion that we let Mr. Bruner's petition go to vote. We can deal with this as a board, regardless of whether we rush into the acceptance of this ordinance or not.
Okay, so are you making an official motion?
Sure. I move that we move forward with the citizens petition going to vote. And we can deal with this under the authority that we have as a board without rushing into
Okay,
a new draft.
so I would suggest that the motion end with send the petition to the voters.
And if I may, it sounds like the motion would be to deny the proposed, the ordinance in your packet.
Well, I don't think the motion is addressing the ordinance in the packet. All it is saying is that we want the petition to go to the voters.
That's not what your agenda is.
That's already the case. And it's just there's still an opportunity for
Okay.
that decision is not in the board's hands tonight. That has already been set for a vote on May 3rd. It's just the case that it could be withdrawn by the petitioners committee not later than 60 days prior to the election.
Well,
No, it's not a drill.
my impression, so Jeff, I appreciate you putting together language that addresses this issue more specifically, but I feel like we're rushing into a review of this draft ordinance when it's obvious that we have more discussion that needs to be had for this to be the way that Mr. Bruner wants it to be and to meet the needs of the board. I feel like we're wasting our time. This is ridiculous.
Okay. So, yeah, Ms. Smith.
I would just add that I think this is exactly what we need to do. We need to adopt this ordinance because it gets to the root of what the people, including myself, that signed the initiative, we're getting at. And I believe that our next meeting, if we have an agenda item to talk about the policy procedure, the applicable procedure.
No,
We have a
let's-
motion on the table. I'd like to second it so we can.
It seemed like the motion was not a legitimate motion because it does not address the agenda item and it's already, so the motion is off. Okay.
So with that in mind, I think this is a perfect resolution to all of the consternation. And then it's up to us to follow up with developing the applicable procedures. So I would like to make two motions.
Okay, we'll do one at a time.
Okay, the first motion is that we accept this ordinance as presented.
Okay, all right, second. All right, further discussion from the board? All right, all in favor?
Aye.
Opposed?
Nay.
All right, the ayes have it. So that motion carries. All right, your second.
My second, I move that we have an agenda item on the March 10th meeting, which includes discussion and this option for decisions. That's not the word, sorry. But you know what I mean?
Just the
To
policy.
set a policy regarding access of trustees to facilities.
Okay, so the motion is to, at the next board meeting, have a draft policy.
I just lost the sound. Sorry.
Oh, lost the sound.
There it is. Okay, there we go.
So
I make a motion that we have an agenda item on the March 10th trustee meeting to discuss a policy regarding viewing all facilities of the town in accordance with applicable procedure.
okay, so we have a
Essentially
motion.
establishing procedure.
Right, okay. Do we have a second? Second. Further discussion from the board.
So we're rewriting a policy.
We're writing the policy.
This is a new policy for facilities access.
Correct.
Okay.
Anything else from the board?
Who's writing it?
Are we coming with a draft or?
Yeah, we're gonna come in with the draft. All right. So we have a motion on the table at the March 10th board meeting to look at a draft, to discuss a draft policy that will allow trustees to have access to public facilities.
We don't need that, it's just a procedure.
It's a policy. So it's a policy, so it's steps to get there. Is that what?
Yes,
Okay,
I think we could just, a motion to, at the March 10th meeting, to develop a policy in accordance with allowing trustees access to view all facilities of the town in accordance with applicable town procedures.
okay. Do you have that, Candy?
I'll get it.
Okay, all right. And we have a second on that motion. All right, all in favor?
Aye.
Opposed? All right, that policy passes, or that motion passes. All right, is there anything else before we adjourn?
Yeah, I have two things I gotta say. One is you now have the right of inspection. The unspoken ramification is with that right of inspection comes the obligation to look. There is no longer any possibility of saying you were not informed. Okay, the other thing is, this is out of order, but I'm not going to be around later tonight, so I'm going to say it now. To the Paonia Board of Trustees, I seek appointment to the Water Advisory Committee. An affordable way to end the moratorium may be available. The possible solution should be explored in the advisory committee. Thank you for your consideration.
All right,
Madam Mayor.
yeah. Oh, yes, Mr. Conklin.
Madam Mayor, I just wanted to make sure and ask Mr. Bruner when we could expect him to submit that withdrawal of the initiative petition.
Oh, I have it.
You have it. Okay, very good. Thanks. Thanks you, everyone.
All
Thank
right,
you.
thank you.
Bye-bye.
All right, well, we need to adjourn this so we can start our work session. So I'm adjourning this meeting. Now we're opening the work session.
They're separate meetings,
Yes.
so we have to do a quick switch.
Oh, okay, and then you have to start recording.
Yes.
Okay. No, I didn't.
Delta County's risk. Very